In this video, we are going to be talking about non-compete agreements and the influence of Indian contract law on non-compete agreements or competition agreements. In the first part of this series, the two-part series that we've been dealing with, we've seen the constitutional and human rights perspective on non-compete agreements and how non-compete agreements should not really infringe on fundamental freedoms or human rights of citizens. However, we now take into perspective the contractual agreement or the contractual liabilities that come into play in such contracts, agreements, or non-compete clauses. Let us now look at the contractual perspective when we analyze the question of non-compete agreements, the legality from a contract's point of view. Let us first look at section 14 of the Indian Contracts Act 1872, which says consent is said to be free when it is not caused by coercion, fraud, undue influence, misrepresentation, or mistake. And why I'm laying emphasis on undue influence is because undue influence could be a crucial factor in non-compete agreements. Let us now read section 16 of the Act. Section 16 of the Act expressly deals with the definition and scope of undue influence, which says, where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. This is enough ground to render the contract voidable. Now, when we are talking about voidability under this clause, what we're really looking at is two major aspects. The first question is understanding the concept of undue influence. The person, one person or one party to this contract, firstly needs to be in a position that he can dominate the will of the other person. And secondly, and this is the qualifying clause to this, he uses that position to obtain an unfair advantage over the other. So it's a very clear twofold aspect. One is there exists that position, and two, that position that exists has been used to obtain an unfair advantage over the other. And this is what you need to look at when we talk about non-compete agreements. And let's get into this at a larger scale, because when you're talking about non-compete agreements, whether it's the sale of a business and the person who's selling it has economic necessity, or whether it's the question of non-compete agreements or non-compete clauses in contractual agreements for employment, you look at all of these, what would really come into question is the fact that these questions of undue influence and free consent would be raised as a question, because we need to really see that whether these people, whether it's a person selling a business out of necessity or a person that really needs that job, is he actually signing out of free consent, or is the circumstance causing him to sign it without much of a choice? In the earlier video, I also spoke about, do we really have a choice as far as signing on the dotted line is concerned? Economic necessity and equality of opportunity were things that we discussed. Do we really have this opportunity of checking or actually vetting the contract to see if this agreement is really violative of our rights or not? And this is something that we need to look at very carefully when we're signing contracts. And when you're talking now about non-compete agreements, there are two aspects that you need to look into. The aspect of voluntary non-fit injuria versus undue influence. Because the general nomenclature, the general way it is looked at is if I sign a contract or if I sign an agreement, I am signing it out of my own free will, which means the element of voluntary non-fit injuria applies. The question that then comes into play is if I am in circumstances that are so compelling that those circumstances operate as an undue influence, those circumstances do not provide me opportunity of actually negotiating these terms, then I'm actually compelled to sign it. Then am I really signing it in a case, and would I be really bound by the doctrine of voluntary non-fit injuria? Therefore, free and fair consent needs to be construed, needs to be interpreted in its true sense. Its real intention, its real motive, and its real substance needs to be analyzed before we come to the fundamental discretion of whether the person should be subjected to voluntary non-fit injuria or whether the question of undue influence applies. I will now get on to section 27 of the Indian Contracts Act, which says agreements in restraint of trade are void. Now, first of all, the distinguishing factor between section 27 as compared to section 16 is section 16 is voidable at the instance of the aggrieved party. Section 27 is void, which means it is void ab initio. Section 27 states every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. Now, when you say it is void to that extent, one is the doctrine of severability would apply. If it could be severed from the rest of it, if it could be severed from the rest of the agreement, obviously that could be considered in terms of operation of that agreement. But an agreement in substance, in pith, would be void if it restrained a person. The exception to this rule, of course, is sale of goodwill, sale of business goodwill, where when a person sells the business goodwill, of course, the person selling the business goodwill would be barred from similar business operations, again for a certain period of time and for reasonable clauses to continue with the same business within certain territorial limits. It goes back to what I said in the earlier video. It talks specifically about three things. One, the territorial limits, if it is for a specific area or a specific place. The duration of the agreement, if it's ad infinitum, which could be restrictive, or it is only for a limited period of time. And thirdly, the fundamental test of reasonableness, whether these clauses are reasonable or not. And these are things that would need to be considered in every contract of non-compete. Therefore, we need to really analyze whether these agreements are reasonable or restrictive. And we'll finally be left with what do we need to do? We'll be finally left with a question which I started the first video: how much is too much? If you are an advocate or a legal professional or a business head, what you need to ensure is that this entire concept of non-compete agreements revolves around a principle of win-win situations. It needs to be one where you secure your interest without harming or without infringing upon the freedoms and the contractual rights of employees or of other parties to this agreement. If you are a person signing it, you're going to ask me, now what do I do? How do I control this situation? First of all, and I say this, please be really careful about non-compete agreements that you sign at the time you are signing it, because looking at it from the point of view of voluntary non-fit injuria, there's a little that can be done after the document is signed. So at a time when you're selling out your business or at the time that you're seeking employment, look at the non-compete clauses. Take a look at it, make sure that it gives you enough room to grow, it has enough space for you to practice your career after signing this document, and it would not be violating any of your rights or freedoms. You need to ensure that you are not getting hurt in the process, and these are things that you need to consider. And therefore, my personal advice to both sides of parties to these agreements, whether you're the employer or whether you are the employee signing it, whether you are the buyer in a business or whether you are the seller of that business, you need to look at a non-compete agreement carefully before you sign it. You need to check these clauses to make sure they are not too restrictive so as to not oppress the other party, and if you are the other party, so as not to be contained and compelled by situations in that contract. You need to make sure your rights are secured. And that leaves us with the fundamental question. It leaves us with food for thought. It leads us to a question that each of us on an ethical basis need to answer. The question of non-compete: how much is too much?